Hi, this is Advocate Lucinda, your empowerment lawyer. A pro se plaintiff contacted me and she was so distraught. The defendant filed a motion to dismiss and alleged that she filed a frivolous lawsuit. Well, she couldn't understand why the defendant filed the motion to dismiss because she was only seeking justice. And we're going to talk about that today. When a motion to dismiss alleges a frivolous lawsuit has been filed, how to respond, and when a claim is not frivolous. The first thing I want to remind pro se plaintiffs and encourage them to mirror the defendant's motion to dismiss. Remember, mirror it procedurally and mirror it substantively, because by mirroring it procedurally, it helps the plaintiff to structure their response in an effective way. It also helps the plaintiff stay on track and keeps them from going down a rabbit hole. Substantively, but counter argue. We are going to define what frivolous is, and also we're going to discuss how to determine a lawsuit's merit before the lawsuit is filed. So let's get started. A frivolous lawsuit is a complaint where it lacks an arguable basis either in law or fact. I have cited a case. It's an interesting case because it gives one the perspective of a frivolous lawsuit from both sides, the defendant's side and the plaintiff's response. So let's look at some elements of a frivolous lawsuit. When the factual contentions are clearly basis. Make sure the contentions have some basis in facts. When the allegations are the product of delusion or fantasy. I think that's clear. When the claim is based on a meritless legal theory that is undisputed. The legal theory must be real, one that can be defined by its own set of elements. And let me show you what I mean. I like to use retaliation for my presentations. For example, retaliation has prima facie elements. In order for the plaintiff to establish a claim for retaliation, they must show they were engaged in a protected activity, that there was an adverse action, and there was a causal connection. Now, the facts must be stated in a way that they demonstrate that the defendant's conduct meets the prima facie elements. Now, in these frivolous lawsuit claims, the defendant will often allege that plaintiff acted in bad faith. A bad faith claim is one filed for an improper purpose, such as to harass. So the plaintiff wants to be sure to file the complaint for a proper purpose and not to harass. The definition of a bad faith claim is when the complaint is filed to cause unnecessary delay or needless increase in the cost of litigation. Again, the plaintiff wants to be sure that when they foul, it is necessary. Plaintiff, pro se plaintiff, it's critical that you understand a case lost on its merit is separate from a frivolous claim. What do I mean here? Although the employee's claim may fail on its merit, and let's say in the retaliation lawsuit that was filed, let's say that the plaintiff loses his or her case. However, it does not mean the lawsuit is frivolous. Losing on the merit is not enough to make the claim frivolous or in bad faith. It's important that plaintiff responds, counter argue the points in which the defendant makes its individual claims of a frivolous lawsuit. Mirror the defendant substantively, but counter argue. And you want to counter argue using facts and law. Next, let's talk about determining the lawsuit's merit. I know I talk about facts a lot, but you can see how critical the facts are. Know your facts very, very, let me add two more, very, very well. I recommend that you IRAC your case before filing a lawsuit. Some time ago, I uploaded a video on how to IRAC a case, and I will include that link in the bottom of the page of this presentation. Law. Identify the law you're bringing the lawsuit under. For example, in this retaliation scenario that we just discussed, plaintiff brought the claim under Title VII for discrimination based on sex. The plaintiff alleged retaliation as a cause of action, claiming that he or she were retaliated again because of their sex. If the plaintiff cannot make a prima facie showing, then the plaintiff does not have a cause of action. And if the plaintiff does not have a cause of action, the plaintiff does not have a lawsuit. The plaintiff should be mindful that if they need to bring the complaint into compliance, they can move to amend the complaint pursuant to Federal Rules of Civil Procedure 15. Plausibility is not only a strong weapon against the motion to dismiss, but also against a frivolous lawsuit claim. We've talked about plausibility. There must be some real reason for supposing that the statement is true. I hope this has been helpful to you. Until next time, I'm Advocate Lucinda. Be empowered.